Thank you. And I would like to reserve 3 minutes for rebuttal, and I will watch my time.
Okay, great.
Thank you. In this case, officers Brian Sullivan and Eli Miley of the Sparks Police Department were investigating crimes of violence that had been committed upon a juvenile. And as the officers approached the suspect in the area outside of the suspect's fourplex unit, the suspect retreated into his enclosed patio and grabbed a previously concealed firearm. It is because of these rapidly evolving life and death situations that the doctrine of qualified immunity exists in the first place. Qualified immunity is designed to protect all but the plainly incompetent or those who knowingly violate the law. The United States Supreme Court has recognized that police officers are often forced to make split-second judgments in circumstances that are tense, uncertain, and rapidly evolving, and have cautioned courts against the use of 20/20 hindsight in favor of deference to the judgment of reasonable officers on the scene.
Counsel, that's all great, but you're talking platitudes here. What I'm concerned about is in the city's responses, instead of arguing the law and citing cases that show that in this factual situation, the officers would have known that they could or could not do certain things, and therefore, if they could do them, they'd be protected by qualified immunity. It seems like the city's arguments were almost entirely fact-based, as opposed to citing appropriate case law that would have protected you almost without a doubt. So I guess I'm a little troubled by that. I would like to focus initially on the issue of the mundane issue of curtilage. You're very familiar with the Hardinez case and others that followed. Were the officers in this case on a curtilage in the sense of the Hardinez case?
Your Honor, it's the city's position that they were not. We do not think that Mr. Brizuela had a reasonable expectation of privacy in the area where the officers were located. We think that pursuant to Dunn, the Dunn factors weigh in favor of a finding that this is not curtilage. And I do understand that the cases of Jardines and London were relied upon by the plaintiffs and by the district court to find that this was curtilage. However, we think those are easily distinguishable because the cases of Jardines and London stand for the proposition that the front porch of a single family residence that is owned, the lot is owned and it's a single family residence, that is curtilage. And we do recognize that. The other case relied upon by the plaintiffs and by the district court is that of Collins v. Virginia. And in that case, the court held that an enclosed carport at the top of a driveway on a single family lot is curtilage. However, it has been recognized by...
Counsel, is your distinction based on that this is a multi-family dwelling? Is that
Yes,
the distinction? Is that okay? What cases do you have to support that?
Thank you, Your Honor. So we provided cases discussing how multifamily dwellings are treated differently. The Second Circuit has explicitly recognized that it's doubtful that the curtilage concept applies to multifamily dwellings at all, and that is in the United States versus Arboleta case.
And on the factual circumstances of what this particular multi-family dwelling is, because I mean, you can look at condominiums that each have their own little front porch area versus, 25-story apartment complexes where the hallways may not be curtilage because they're expected that the members of the public will walk through the hallways. But, and so there's not really, the hallways won't be protected, so that means necessarily that all the way up. So I think it's just like the first question that Judge Smith asked you. I think this is very factual dependent issue.
I agree. I understand that. So in this case, in the Brizuela case, we have a fourplex unit. So it's one building that's split into 4 units. The units that the officers were facing was the front doors of 2 of the units, and the front doors of the other 2 were on the back side. So to the front of the building, it looks like a duplex. And there happens to be 2 units attached on the other side as well. And the 10th Circuit has held that a duplex, which is similar to what we dealt with in this case, the front yard of a duplex and even anything that can be seen from the front yard of a duplex is not curtilage. And in that case,
in this case, they were standing on the steps and knocking on the door and looking into the enclosed patio.
Correct.
Isn't that true?
Yes, that's correct. And in the Reeves case, the 10th Circuit case, the officer in that case placed the barrel of his rifle into the window of the bedroom. And the 10th Circuit held that that was not a violation that was not a Fourth Amendment reasonable expectation of privacy because it's a duplex, front yard duplex.
Let me ask you this. Let's assume arguendo that the officers did, in fact, step on a curtilage. What's the city's position about what possible damages the plaintiffs could have suffered as a result just of having stepped onto the curtilage?
I'm not sure I understand the question. So I believe
that we're breaking this down into subparts. The first claim is that they violated the curtilage. And the question I have is, okay, if they did, what possible damages could the plaintiffs get from this? I know they're going to have a different position than you will, but I'm interested in your position from respect to the city. Would you say, well, nothing was damaged, nobody hurt anybody, nobody did anything? What would be your response?
Correct. I think up until the point that firearms were pulled, I don't think there's any damages here. I think that the officers were standing on the front porch of a duplex for approximately 45 seconds before firearms were pulled. And up until that point, I don't think there's any damages incurred.
But you say that's not the curtilage on the steps of the place?
Yes. Yes, I do firmly
because
believe
it goes to more than one unit, is what you're saying.
The front porch
does not.
Correct.
Yes, it does not go. The front porch does not go to more than one unit.
That is correct. The front porch does lead directly to the front door of the Brizuela's unit. And if you're standing on this front porch area, which is really just a concrete landing step situation, directly in front of it is the front porch of the unit. I'm sorry, the front door of the unit. And then directly to the left is the gate that leads into the enclosed patio where Mr. Brizuela ended up standing during the encounter. So the officers were standing on the front landing, directly in front of the front door, adjacent to the gate to the front patio. We are of the position that that is not curtilage under the Dunn factors as a matter of law, or at the very least, it's not clearly established beyond debate that a multifamily dwelling's front yard, front porch area is curtilage.
So can I just go back? You filed a motion for summary judgment based on qualified immunity for the officers, right?
On the merits of the case as well as qualified immunity.
Okay, but before us is an interlocutory appeal of the qualified immunity determination, right?
Yes.
So just to go all the way back full circle to Judge Smith's initial question, the district court found that there were genuine issues of disputed fact that precluded it from ruling on summary judgment in favor of the officers on qualified immunity. It did not find that if the facts were found to be what the officers said, that they would not have qualified immunity. It just said, we need to first determine the facts, such as whether Brizuela was facing the officers at the time of the incident, and whether he actually raised his gun toward the officers. And once we determine those facts, then we can rule on qualified immunity. So how in the world do we have jurisdiction over this appeal when the facts are still moving? Even the facts as to the nature and location of the curtilage haven't really been fully established. We just have to assume all the facts. I don't know, maybe this is motion. We're just assuming all the facts in the light most favorable to Brizuela at this point and saying, if his story is true, are the officers entitled to qualified immunity? And on his story, we can't say that they are. On his facts, on your officer's facts, we can say yes, because based on their version of the facts, but that's not how we have to look at this case at this procedural juncture.
I understand. So up until this point, and to Mr. Goldstein can correct me if I'm wrong, most of the facts are not disputed. The facts as to curtilage are not disputed. That's simply, we agree about the layout and who owned what and what the uses were used for, the areas were used for. So the facts as to curtilage.
So you're stipulating this was curtilage? Is that what you're saying?
No, I'm saying as a matter of law, it is not curtilage. We don't dispute, Mr. Goldstein and I don't dispute the factual layout, where things were located, but we do dispute whether or not as a matter of law, it constitutes curtilage under Dunn. The only facts that are actually disputed in this case tend toward the excessive force claim, and there's two facts that are disputed by Mr. Goldstein, one of which is whether or not Mr. Brizuela was facing the officers or not, and the other fact is whether or not he started raising that gun toward the officers. The city's got two positions on appeal here before your honors. We do believe you have interlocutory jurisdiction because even for purposes of the summary judgment, taking all reasonable inferences in favor of the plaintiff, if we disregard those two facts, if we disregard whether or not he raised the gun, we do believe they are still entitled to qualified immunity on the deadly force, excessive force claim under the Graham factors. However, we also believe that the court can consider the whole record on this de novo review and look at all of the facts because the United States Supreme Court and this court have recognized that if the findings of the district court are based on a blatantly contradicted version of the facts,
Right.
they should not be adopted.
But we've held that where you have a video that shows exactly what happened, and you can, right? I mean, you can see, that the video says exactly what happened, and you can clearly see it because it's not just from one particular vantage point or something. This is really what happened, and they're arguing that the facts are in dispute, saying, no, that's not really what happened. That's when that rule comes into play, not when people are, we don't have a video here. We're not, I mean, we have to rely on witnesses to say what happened in this case.
I understand, Your Honor. So Scott v. Harris is the primary case, and yes, there is a great video in that case. Our case, the video is not perfect, unfortunately, because of the location of the patio wall. However, this court in Wilkinson did determine not to adopt the facts of the district court, and I do not believe there was a video in that case. I could be incorrect, but I believe that was simply...
Well, I'm just remembering that it was when it's so clear that the plaintiff's version of the facts can't be true, then you don't accept the plaintiff's version. But here, it's not so clear what actually happened.
So I believe that it is clear. So that what the video does show is that, and what is undisputed is Mr. Brizuela retrieved a previously concealed firearm and he was holding it in his hand. That is undisputed. At that point, the officers held him at gunpoint for 34 seconds, attempting to have him put the gun down. They held him at gunpoint and it's on video. And then simultaneously, both officers began shooting after 34 seconds of attempting to de-escalate the situation, which I believe is corroborative evidence to substantiate their testimony that something changed. In addition to that, we have the fact that he was found face down, which substantiates Officer Sullivan's testimony that they began firing when he was facing them, as evidenced by the fact that the bullet did enter
I thought every one of the bullets except one, and there was a number of bullets, were in the back.
So, correct, Your Honor, there was 11 total, one of which hit the front of his body, 10, bad at math, 10 of which hit the side and back of his body. It would defy logic to assume that he was facing away from the officers and he landed face down if one of the bullets entered the front of his body, which is what the evidence shows. So all of the evidence actually corroborates the officer's testimony, and there's zero evidence, admissible evidence, that vitiates their testimony, that undermines it. So we do believe that you can consider the record as a whole, but if you don't want to go that far, we do believe that the facts that are undisputed justify deadly force or at the very least qualified immunity.
Okay, why don't you reserve, you have a minute and a half left. Why don't you reserve so we can hear from the other side and then you can respond.
Thank you.
Good morning. This is Peter Goldstein. It please the court. I would like to start with the curtilage argument because that was the first question that Judge Smith raised. The London case and the Ardeen's case make it clear that the front porch is curtilage. I mean, there's no question about that. We don't dispute the facts of where the officers were. They were standing on the Brizuela's front porch. We believe that the law is very clear that that is curtilage, property of the Brizuelas. And Mr. Brizuela made it abundantly clear to both officers that they need a judge's order. They have to leave. He doesn't want to engage with them in further conversation. And they are on his property.
Okay, counsel, let's take what you say as correct arguendo. What damages do your clients have, just breaking this down, as a result of their being illegally on the curtilage of your client's property?
Well, I mean, in one case that we cited, the estate of Sauceda versus City of North Las Vegas, the violation of as well as expectations of privacy and the standing on the porch approximately caused the death of Mr. Brizuela.
Well, that's a step beyond. I'm just talking about breaking this down here. What damage flow? You claim that they have illegally trespassed on the curtilage, and what I'm asking, just that alone, what damage flows from that?
Well, it's hard to segregate that particular violation from the totality of what happened, but specifically with respect to standing on the front porch, I can't say that caused the death of Mr. Brizuela, but after Mr. Brizuela's continued protestations that they must leave, and they failed to leave, that escalated the situation into a more intense, aggravated encounter. So that was the predicate act that really led to the dispute that with respect to both the officers and Mr. Brizuela. Mr. Brizuela's statements that they had to leave, their defiant response to those statements that no, they're going to do what they want to do. They are continuing to knocking loudly on the door. All of that has to factor into the fact that ultimately proximate cause analysis leads to the death of Mr. Brizuela. He did not have a gun, by the way, until later on in the event. And I have to dispute what Ms. Northington said about the fact that he was facing down. He was prone. His head was facing away from the officers. There were two fatal shots, one in the back of his head, one in the back of his neck. The one shot that was to the front was actually to the side that hit one pectoralis major and came out the other side of the pectoralis major. So it was a side shot. It was not fatal, according to the coroner. And that was the only shot that was to the front of or the side of Mr. Brizuela's body. But again, under the proximate cause analysis, I believe that standing on the curtilage and defying Mr. Brizuela did lead to the death of Mr.
Counsel,
Brizuela.
where in the record would you refer us that says that your client did not have a firearm?
Well, according to the deposition testimony of the officers, when he was talking with them initially, he didn't have a firearm.
Did they say that?
They did not see any firearm.
Okay, but that doesn't mean he didn't have a firearm, right?
Well, what they said later on in their deposition testimony and in their statements was that Mr. Brizuela then went to the other side of the enclosed patio, and there was a table there, and he reached for something. His back was to them, and they believed that was when he grabbed a gun. After he accused them,
and cocked it.
well, that's a disputed issue of fact. I mean, he never aimed it, and I believe Judge Sauter wrote an opinion on this issue directly on point. You can have a gun and even rack the slide, but there's no testimony that he actually aimed the firearm at the officers. He was in a defensive position, and he never aimed it. But there's a dispute about whether he racked the slide. That can't be heard specifically in the body cam footage.
Did the officers say they heard a racking?
They did. We also, having listened to the video multiple times, I mean, there's a lot of loud pops, clicks, and crashes, and then finally the gunshots. But you really can't hear a specific rack. But even if he did rack the slide, he had the gun down. That's undisputed. It was not even close to 90 degrees. It was not aimed at them. And they were not in fear of immediate threat of death or great bodily harm.
How do you know any of that? How would you know that the gun was aiming down?
Because that's the testimony of Officers Miley and Sullivan.
They said that he didn't ever point it at them.
They said that it was never close to 90 degrees. He did not raise it. And they were not in fear of death.
And they said they had no fear that they were going to be shot.
That's correct.
And they didn't say gun, gun, and warn each other?
They did say gun, 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 and warn each other.
Oh, they just did that to the exercise, right? They weren't really fearful?
I don't know, but the analysis is based on their objective reasonableness. Subjectively, they said in their deposition testimony that they were not fearful at the time when they looked over, and one of them...
And until they heard the racking, if I read the record correctly, that was at that point that one of them said, gun, and at that point, they were worried they were going to get shot, and that's when they pulled out their firearms, not before. Isn't that correct?
They pulled out their firearms, after Mr. Brizuela asked them to leave multiple times, after that he went and grabbed something, but they couldn't see it clearly because there's factual disputes about what they could actually see inside of that.
But they heard a gun. They heard a gun being racked, right? They know what that is.
I don't know if they just specifically could have heard the racking of a gun.
They said they did.
They said they heard something. It could have been the racking of the slide.
I thought they said they heard a gun being racked.
If that's the record, that's the record. But I believe Mr. Sullivan, in his deposition, Officer Sullivan stated that there was no immediate threat, and he held the gun to his side.
Where do you think that the officers got onto the curtilage? Is when they stepped up on the step or got on this little porch or whatever it was? What is your position?
Our position is that the porch itself is unquestionably, undisputably curtilage. That law is well established. This is not a consensual encounter. Prior to their even stepping on the porch, they were asked to leave by Mr. Brizuela many, many times. They refused to acknowledge his desire that they leave and end the encounter. So it was when they stepped on the porch, that is a violation of the expectation of privacy, and they were now on the curtilage on his property against his will. And they made contradictory statements as far as the racking of the slide, but we believe that the walkway is curtilage too, because it only goes to that particular door, front door of the Brizuela residence. There's no other residence that walkway leads to. It's only the Brizuela's residence.
When you look at the picture, there's grass on both sides, and there's a walkway. Does the homeowners association or someone deputized by them mow the lawn, or is that what Mr. Brizuela would do?
I understand that the homeowners association does some of the maintenance in the front lawn.
So basically, the area that you're talking about basically is, if we were to look at a subdivision map, that would be common area property. Is that correct?
The particular walkway itself?
Yeah, the walkway and the grass on each side.
Yes, I believe that is what the plots do show. But I don't believe that's the linchpin of how we determine what is curtilage. It's what even the officers themselves in their testimony stated, that they believed that they were on the curtilage of the Brizuela residence when they were on the porch. And that's when the fatal interaction began, not when they were on the walkway, or they were never really on the grass initially. But that's what we believe is dispositive on the issue of curtilage. They're on the porch. They've been asked to leave. They should have left right there. So there's no knock and talk exception. It's not consensual. And there's no question that this is curtilage, because the case law is very clear. Even there's a case that Judge Wardlaw wrote on curtilage as well, Perea Ray case involving a carport where it was determined to be curtilage, unquestionably, adjacent to the person's home. So is it around, adjacent to the home? Yes, right there, right against the door. The officers themselves called it his porch. The witness, Miss Register, said it was their porch. Nobody looked at plot maps and recorded deeds to determine who owns what. This analysis really goes to what a reasonable person, what is customary in the community, what we believe to be an expectation of privacy. And For example, in the Jardine case, I mean, they took the dog sniffing dog onto the porch of the property and then determined from an uncorroborated informant that there might be marijuana in the property, and then that was determined to be curtilage, unquestionably. So, back to your initial question, nominal damages for the violation of the curtilage law by standing on the porch. I mean, we're not claiming the death itself, but we do argue proximate causation, but nominal damages for that wrongful conduct and possibly punitive damages and attorney's fees. That's arguably damages from that violation of the curtilage law.
Would you go back to, there seems to be so many genuine issues of disputed fact here. I don't know how we can say the officers were or were not entitled to qualified immunity, which means we don't have jurisdiction over this.
Yeah, our argument is that there is no issue, that there's no jurisdiction over this issue of qualified immunity at this time. The only issue that the court really has jurisdiction over, as I see it, is the finding by Judge Dew in her order that the officers violated the Fourth Amendment by unlawfully searching or intruding on the property of the Brizuelas after being asked to leave. That's a finding. That's an order by Judge Dew. That's a violation of the first claim, and that the court has jurisdiction over, because Judge Dew said, as a matter of law, that's a violation of the Fourth Amendment, and the plaintiffs prevail on that.
I think, do we have jurisdiction over the familial damages claim? So I guess does qualified immunity?
No, I don't believe that this court does, based on the disputed facts, that there is jurisdiction over the familial damages claim. There are factual disputes, and the court noted that.
Okay.
Did the city raise qualified immunity with respect to the familial damages claim?
No, they raised the qualified immunity defense regarding the excessive force claim.
And none of the other claims?
Well, they did not prevail on the first claim for relief on the unlawful search, but they did not make a compelling argument to the district court judge that...
That's a different issue. My question to you is, did they raise qualified immunity with respect to the balance of these claims?
I may have misspoke. I believe that they did raise the defense of qualified immunity on the deprivation of familial relations claim. But again, that goes back to the disputed facts.
Well, clearly, if the disputed facts, that's one thing. But if there's absolutely no law to back it up, doesn't qualified immunity still obtain?
Well,
for example, the Second Amendment claim.
Yes.
Quite a novel theory, but your idea that the Second Amendment protected from Mr. Brizuela racking a firearm is novel.
I don't think it's so novel, given Brune and Heller and McDonald. I mean, maybe novel, but it's, I mean, there is now a Second Amendment right to have a gun in your home.
Yeah, and the purpose of the gun, and did Mr. Brizuela use it for an unlawful purpose? He didn't brandish it at the officers and say, I have a gun, I'm pointing it at you and you must leave. He didn't use that as a threat against them. He did it, he used it in a manner that the Second Amendment provides. I mean, this is the sanctity of his home. He thought they were thieves. They kept ignoring his request that they leave, and then he said, are you thieves? I mean, he could not believe that they were still there after he said over and over again, you must leave. So I believe that there is a valid Second Amendment claim, and the court acknowledged that as well in Judge Dew's order. Is there any other specific
Does anyone else have any other questions?
No.
Okay, no, but thank you, counsel. And Ms. Northington, I think you have a couple minutes. Well, you have a minute and a half.
Yes, thank you, Your
You
Honor.
don't have to use it all.
Thank you. Just a couple points I would like to make.
Okay.
Clarify, we asserted the qualified immunity defense to every constitutional claim, including familiar relations, including the Second Amendment. And then as to the curtilage issue, we believe that the conflicting case law alone on whether or not a multifamily dwelling, the front porch area is curtilage or not, entitles us to qualified immunity. The purpose of presenting the evidence of the fact that this whole area, including the front porch, is designated a common area by pursuant to like the plat maps, and that the HOA does all the maintenance and snow removal, it is not for purposes of determining what the officers believed. It's because Mr. Brizuela has to establish that he knew he had a legitimate expectation of privacy, which he did not.
No, but
That
you
is-
guys keep talking about legitimate expectation and privacy about it. It's really the Supreme Court has, I think it was the Hardina's case, said this is really, there's two forms. There's property. If the common law of trespass applies, I think that's Justice Scalia has written about that. It's the property, and in addition, it's the reasonable expectation of privacy. This was the Brizuela's property, their front porch.
So first, it was not their property; they didn't own it. So therefore, the done factors come into play
But
because
they're
they.
occupying it as though they own it. You can't say that if they'd gone into the actual home, just because the Brizuelas didn't own it, that was an invasion of their home. And the curtilage is equal to the home in terms of the extension of the rights.
Correct. What I mean by they didn't own it was that this was the common area of the HOA. It was designated common area of the HOA. The Jardines case is single family residence. We do think that's distinguishable, especially given the Second Circuit and 10th Circuit case law on this, which at the very least entitles us to qualified immunity on the curtilage issue, because there's contrary case law, conflicting case law about whether or not the area.
Counsel, you're familiar with the cases that say even people inside their hotel rooms have are entitled to privacy.
Correct. And the Dunn case itself said that the people weren't entitled to privacy in their own barn, which was within multiple fenced enclosures. The officers in Dunn were allowed to go over 3 or 4 fences to get to a barn on someone's
I
property.
think our discussion just shows how factually intensive this is. So you're a minute over.
Can I just ask one quick
Yeah, sure.
wind-up question? What is the basis for your argument that we have jurisdiction over either the Monell claims or the state law claims?
So the Monell claim is the constitutional basis. We asserted qualified immunity on the constitutional claims, and if the constitutional claims fail, the Monell claim fails. We're not addressing the policy or the ratification, just the constitutional prong of Monell. As to the state law claims, we asserted pendant jurisdiction because the state law claims of battery is the same fact and legal analysis as excessive force. The wrongful arrest, false arrest is the same as search and seizure, and the negligence involves immunities. So we do think that the court has pendant jurisdiction over those related claims.
All right. Thank you, counsel.
Thank you.
Brizuela versus Sparks is submitted.